Okay, we'll just give another minute or so. I see people are still joining. Hi, everyone. Welcome. We'll just start in another minute or so. Okay, good afternoon, everyone, and welcome to today's estate planning webinar. I'm pleased to introduce our presenters for today. We have Ahmed Aslam, partner at Zeifmans, Brett Rowan, partner at R&D Law, and Nima Salehi, co-founder of Valid Insurance. All three of our speakers today bring valuable experience and expertise in estate planning, and they'll be sharing practical insights to help us better understand some of the key considerations when it comes to planning for the future. We will save 5 to 7 minutes at the end for questions, and this webinar will be recorded. Okay, Ahmed, I'll pass it over to you.
Many thanks, everyone, for joining today's presentation. Let's begin with the first understanding what estate planning is, and then we can talk about some of the strategies we typically use, and then I will invite Nima and Brett to share their thoughts as well. So let's start with what estate planning is. Essentially, it is an integrated management of succession, incapacity, tax, liquidity, and control issues arising on death. In this context today, we will discuss the important components of the estate planning: tax, legal, and insurance. In Canadian tax context, the planning the principal starting point is the deemed disposition regime on death under subsection 70 sub 5. So before we get into the actual planning component of the presentation, let's first understand what happens if we do nothing. So subsection 70 sub 5 generally deems capital property to be disposed of immediately before death at fair market value at that point in time. This results in crystallizing any accrued gains on your marketable securities portfolio, real estate, private company shares, partnership interest, and any other capital property. Any registered plans, such as RSPs, RIFs you may have, result in full income inclusion in the absence of any available rollover. Without a valid will, provincial law generally determines who receives the estate, which may cause delays, disputes, additional cost, missed tax deferral opportunities. And lastly, provincial probate and estate administration tax and legal administration costs may further erode the value of the estate. So that's why it is very important that we always plan for and have a proper plan in place to manage the potential tax exposures and minimize the consequences of some of these issues we just discussed. So some of the main benefits of the estate planning are it gives you clear direction and control. A will, a trust, coordinated beneficiary designation can determine who receives the assets, when they receive them, and on what conditions. This helps ensure the distribution that reflects your wishes rather than the provincial rules. Protection of vulnerable beneficiaries is an important component of the estate plan. Trust and tailored distribution provisions can protect minors, surviving spouses. They may also provide structured access to the funds and reduce the risk of mismanagement or family law complications. Tax deferral is an important element. Planning may allow you to defer tax by implementing some of the strategies we're going to learn today. Asset preservation, ownership, succession, valuation, insurance, and liquidity can be coordinated to address illiquid or high-value assets. This can help preserve a cherished family cottage or a business, support an orderly transfer, and reduce the risk of forced sale to fund the potential tax obligation which may arise. And lastly, it reduces risk and creates administrative efficiency. Clear wills, shareholder agreements, power of attorneys, trust help reduce uncertainty. And coordinating those documents can limit conflicts, court intervention, or delays in transferring the assets to intended beneficiaries. Now let's talk about some of the main tools which are available for us to manage this process. Wills, trust, and coordinated beneficiary designation can help determine who receives your assets, when they receive them, and on what condition they receive them. This helps ensure distribution reflects your wishes rather than provincial rules. Protection of beneficiaries, we talked about it already. We mentioned tax deferral strategies which can be implemented. Sorry, I think I'm missing my slide. Okay, sorry, I'm back on that. So wills typically take effect on death, and it identifies the executors, beneficiaries, trustees, guardians, and intended distribution of the estate assets. It can also direct the use of the tax planning provisions which may be available, including transfer intended to qualify for the spousal rollover. Power of attorneys for the property operates during your lifetime and authorizes another individual to manage financial affairs if individual is unavailable or incapacitated. Power of attorney for personal care authorizes decisions about your medical treatment, housing, hygiene, safety, and other personal matters during incapacity. Family trust generally comes in, and let's talk a little bit more about family trust because it's a tool which we typically use quite often. There are typically two types of trust generally used in the estate planning context. One is the inter vivo family trust. It's established during the settler's lifetime with trustees holding and managing assets for the beneficiaries. It provides control or stage distribution. It can provide support for minors or beneficiaries with disabilities. It can protect against financial mismanagements or certain creditors and certain family law risks. It provides protection against financial mismanagement. It creates an element of privacy, which the standard probate process is an open process. Everybody has access to that. While trust structure is more of an opaque structure, which provides certain measure of privacy. And lastly, it possibly reduces the exposure to the probate, which we will talk about it perhaps if time allows, but it can be costly depending upon the value of the estate. And the second type of trust which we use in the estate planning context is the testamentary trust. This is created or arises as a consequence of individual's death under the will, and it can preserve capital for residual beneficiaries while providing access to income and capital to surviving spouse or other beneficiaries under defined terms, which you described. A qualifying spousal trust may also allow you to defer tax by by rolling over the qualifying property under subsection 70 sub 6. There are certain conditions attached to it, and if time permits, we can get into that as well. What I do want to emphasize is that drafting the trust document must align tax objectives, provincial trust rules, and succession laws. Lastly, life insurance policies are used, and Nima will expand on that during his part of the presentation. Okay, so let's talk about the more commonly used objective is to preserve the value you have created by having a very successful business from which you start from scratch. As I mentioned, under the Canadian rules, there is a deemed disposition of assets upon death. That includes any shares of private corporation, the business you own is deemed to have disposed at the value on that date. And that's where we typically see a very significant efficiency or significant benefit in terms of the tax planning. So let's just expand a little bit more in terms of how the process works, and then we can talk about some of the tools available for that. A succession, may involve either a sale to the third party. You can control that process from start to finish, but it does result in immediate tax consequences, and which may be significant. Another option for succession would be for employee buyout, which allows you to keep control in the hands of the people you trust, you have worked with during your life. And but it does require carefully financing considerations to make sure that that you end up with the intended results. And lastly, where we see most tax efficiency is transfer to the family. If structured right, this results in significant tax savings, but it does require family readiness. You have to have some family members who are active in the business or who are able to take over the business. The second element of the business succession planning is knowing your corporate structure. Before you plan, you have to have a good understanding of what the fair value is, what your cost base is, what's the paid up capital, what are the shareholder rights, what's the ownership structure, any debt, any tax account, and any other significant assets owned by the business. You want to have a fairly good understanding of that. This foundation is essential for a tax plan which will follow. As previously mentioned, on that in Canada, you are taxed at your unrealized gains. So let's take a very high level example. Let's say you have a business which is valued at $5 million. And your cost base of the business, let's assume to be $500,000. So that results in capital gains of about $4.5 million. And the resulting tax on that, on your final return is about $1 million, a little bit more than $1 million. And the issue is that this is just a deemed disposition. There is no actual liquidity event. You don't have any cash resulting from this reporting of $4.5 million gain. So your estate may not have the cash to pay. So this is a real driver for succession planning. Estate freeze is one of the common elements which is used in estate planning. A common strategy involves exchanging your common shares, which are your shares, growth shares of the business, for fixed value preferred shares. And in order for you to benefit from it, you typically do that when valuation is still low, the business is still growing. And if you put that plan in place at that point in time, you can manage or defer a significant amount of tax as a result of the section 70 sub 5. All future growth then from that point on goes to the next generation. When you die, only the preferred shares are deemed to be sold, and those are fixed value shares. They don't appreciate in value from that point on since you put this plan in place, leaving all that future growth in the hands of your heirs and outside of the tax authorities' purview, and that future growth is not taxed upon that. There are some post-mortem planning opportunities as well. Even after that, you can execute those. For example, you can use the losses to recover tax. You can carry back losses in certain conditions, and you can implement a pipeline strategy. The bottom line is that you gotta start early, and once you're gone, either some of these options disappear or become very limited. That's why we prefer that we start this process as soon as you have significant assets and you are able to then put that plan in motion and all the future growth gets transferred to the next generation and not taxed upon that. Okay, let's go to the next slide. So what the process usually looks like. I typically say that it's a 6-stage process. The first stage is we gather information, we identify all the assets, liabilities, business interest, insurance policies, existing state documents. We review the existing ownership structure, beneficiary designation. Once we have gathered all that information, we will identify what your objectives are, determine your family objectives, tax objectives, business succession objectives, charitable giving if you plan to do so, and asset protection goals. And consider the needs of your spouse, children, minors, any other beneficiaries you want to address through this process. And the third stage would be to assess potential tax and liquidity exposure as a result of when you identified all those assets and liabilities. That allows you to have a very good understanding of what the potential tax bill looks like at that point in time. And then once we have an estimate of tax, then we can develop a plan. The plan involves coordinating the wills, power of attorney, setting up the family trust, beneficiary designations, ownership arrangements, having an insurance policy in place, addressing the business succession planning, and private share planning, which we just highlighted a couple of slides ago. Once you have the plan developed, then you go into the fifth stage, which is the implementation and the communication to all the parties involved. You execute all the legal documents, update designations, arrange funding, any shareholder agreements get finalized. You ensure that all of the legal, tax, financial, insurance elements operate consistently. And lastly, which I highlight and often gets missed, is that no plan is is going to be the final plan forever and a day. You gotta go back and review and update, revisit the plan periodically. Often major events such as marriage, separation, or death, or birth of a child, the sale of a business or significant assets, or move between the provinces, or significant tax law change requires that you revisit and update your plan. So that brings me to the end of my presentation. I will now invite Brett to go over some of the legal considerations involved in this process. Brett?
Great. So thanks very much, Ahmed. So as we've just heard, estate planning is much more than about having a will or dealing with taxes on death. For business owners in particular, an important part of that planning is thinking about what ultimately happens to the business itself. For many entrepreneurs, their business is their largest asset and may represent decades of hard work and a significant portion of the wealth they've created. So succession planning shouldn't begin when retirement or a sale is just around the corner. Ideally, it begins years in advance. From a corporate law perspective, the objective is to ensure the business and its legal structure give owners flexibility when that transition happens. And succession planning, as Ahmed outlined, doesn't necessarily mean passing the business to your children. It could mean a family transition, or it could mean a management buyout, a third-party sale, bringing in a new shareholder, or just ensuring the business can continue if something unexpected happens to an owner. So generally speaking, the earlier you plan, the more options you have. And as Ahmed discussed, the corporate planning needs to work together with the tax, insurance, and broader estate planning. So one of the first things we look at is whether a corporation itself is ready for a transition, and just how many successful businesses have minute books that, well, either don't exist or haven't been updated in years. We see things like unsigned resolutions, incomplete share ownership records, and shareholder agreements that no longer reflect how the owners are actually operating the business. These issues often go unnoticed until something important happens, like a financing, a new shareholder coming on board, a succession event, or even a sale, and that's generally the worst time to discover them. If you're selling a business, for example, and a purchaser begins legal due diligence, you don't want to be figuring out whether your shareholder register is accurate, whether shares were properly issued or transferred, or whether significant transactions were properly authorized. These problems can significantly increase costs. They can delay a transaction, scare off purchasers, or give a purchaser leverage to renegotiate the purchase price. So relatively simple corporate housekeeping can make future succession considerably easier. So building the right legal framework. So the next piece is making sure that the ownership structure continues to make sense as the business evolves. The structure, for example, that worked when someone incorporated a business 5, 10, 20 years ago may not be appropriate once the company has grown substantially, accumulated assets, added shareholders, or started preparing for succession. As corporate counsel, we look at who owns the shares, the classes and rights attached to those shares, and whether the structure still supports the owner's long-term objectives. And depending on the circumstances, that may involve the introduction of holding companies, discretionary family trusts, different classes of shares, or other corporate planning tools. And this is really where the corporate lawyer and the tax advisor need to work closely together. My role as corporate counsel is to understand what the business owner and their tax and estates advisors are trying to accomplish, and then ensure that the corporate structure and legal documentation actually support that plan. So the key takeaway is that your corporate structure should facilitate your succession plan rather than having your succession plan dictated by an outdated structure. Next is shareholder agreement. So anytime there's more than one shareholder, one of the most important succession planning documents is the shareholder agreement. And we often think of shareholder agreements as dealing with things like governance, voting rights, and disputes. And while they do speak to those matters, they're also very important business continuity documents. A good shareholder agreement answers fundamental questions before a problem arises. So what happens, for example, if a shareholder dies, becomes disabled, or wants to retire? Can their family inherit or receive those shares, or do the other shareholders have the right or even the obligation to buy them? If so, how is that purchase price determined, and where does the money come from to fund that purchase? Now, these sorts of conversations are much easier to have while everyone is healthy, involved in the business, and aligned than they are after one of those events has occurred. Now, properly structured shareholder agreement establishes those rules far in advance, including the buy-sell mechanism, valuation process, payment terms, and continuity arrangements. And this is really where the corporate planning connects directly with the insurance planning that Nima is going to discuss next. For instance, if the shareholders agree that one shareholder will purchase the other's shares on death, where does that money come from to fund that purchase? If life insurance is intended to provide that liquidity, the insurance arrangements and shareholder agreement need to work together. So really, if there's one broader theme I'd like to leave you with from the corporate law side, it's to make the plan before you actually need to rely on the plan, and to keep that plan up to date. So ideally, your corporate records, your ownership structure, your shareholder agreements, your tax planning and insurance arrangements are already working together when a succession event occurs, rather than trying to figure everything out afterwards. So with that, I'll turn it over to Nima to take us through the insurance side of succession planning for business owners.
Thank you, Brett. Thanks for having me, everyone. So far, Ahmed and Brett established the ground for the best practices to set up the right legal structure and proper tax strategies for your estate plan. Now we are going to look how life insurance particularly can finish the job with confidence. In reality, an estate plan is only as strong as the funding behind it. Insurance is often known and used as one of the most cost-efficient and reliable funding tools for making an estate plan. Why is that? Here are the top four reasons for this. Number one is obviously liquidity, as Ahmed already touched on that. Guaranteed liquidity almost. Life insurance can provide cash, and the cash can cover the tax bills and other estate liabilities that trigger on death. So the asset does not need to be sold under pressure. Second, the death benefit is exempt under the Income Tax Act of Canada and excluded from the definition of the deemed disposition. That offers a lot of tax simplicity and efficiency right there. If the policy is owned corporately, as both Ahmed and Brett mentioned, it could be a case. Through the capital dividend account, the life insurance proceeds still flow through your shareholders and estate on a tax-free basis. The life insurance is not only for the death, for the time of the death. It can become a living benefit, and a permanent policy provides a tax-sheltered cash value growth inside the policy, inside your corporate, and often used for your corporate retirement planning. Time is not your best friend here. You buy your life insurance or your living benefits by your health and age. These two are the actual purchasing power of yours. It's not the money. It's the health and the age that it's your purchasing power. Insurance companies are very risk calculated. They fully examine your medical and health conditions before they offer you a contract. So medical eligibility is not guaranteed, is not constant. It changes over time. Your insurability as a result simply can be lost because of a health change, or when you pass a certain age, or because of a new risk factor. Also keep in mind that medical underwriting is a nuanced process. How your case is presented to an insurance company can make a material difference. You can receive a standard rate based on that, or you can become rated or completely declined. So always ask your insurance advisor how they prepare and present your case to the insurance companies, because it matters a lot. When it comes to selecting an insurance company, keep in mind, choose a company with a proven claim paying history. Choose a company that has a very strong financial strength, and also keep in mind to pick a product that offers flexibility. As Ahmed and Brett already mentioned, estate plans, they evolve over time, and you want to have a product can be adjusted and evolve through your needs and your future estate plan kind of roadmap. Ahmed and Brett already explained about estate planning, and it may take time. Maybe it takes weeks or months. And when it comes to insurance planning, the best practice is to start a simple term insurance with a term conversion right. So whenever the time it comes that you would have the final version of your estate plan, you can basically transfer the policy through that and use it there by using the conversion right. One of the major questions that we always ask is that who should own the policy? Should it be owned personally by my operating company, by my holding company, by a family trust? And that has to be decided early on in the process. It is in your best interest not to decide to move the policy between your companies, because it can trigger some tax liabilities. So if you're not sure where the policy has to be placed, personally, OPCO, holding company, or family trust, that's a very good reason to talk to your insurance advisor about how to design an interim ownership plan and a solution in place. As Brett already mentioned, a shareholder agreement is one of the tools that can help you to become proactive about your business planning. But here are a few caveats that you have to keep in mind. Similarly to an estate plan, a shareholder agreement is also as strong as the funding behind it. There could be few triggers here. As we discussed already, insurance is typically used in order to finance the buy-sell provision in case of death. Whether it's structured as a cross purchase or corporate redemption, that's one of the major tools, or one of the most commonly used tools in order to finance that. Secondly, some disability or critical illnesses, they can also trigger part of your shareholder agreement, and they may need funding too. So similarly, disability insurances and critical illness insurances, they can become a cost-effective tool and be coordinated with your shareholder agreement in order to finance them when the time is coming. And finally, retirement is also an important event in life. It's a living benefit that we always wanted to have in place. And corporate savings, or the tax sheltered cash value of the permanent life insurance policies, or a combination of both, can help you right there. And I would like to conclude that, as both Ahmed and Brett mentioned, life is not a static point. Everything has change is the only constant we are dealing with. Commit to annual coverage reviews, commit to annual legal reviews, commit to annual tax strategy reviews, because your business evolves over time, the value of your business evolves over time. And when you are doing the constant checkups, it boosts your resiliency, it boosts your business continuity, and it gives you the confidence that you're always ready for unforeseen events. With that, I would pass it back to you, Monica.
Thank you so much, Nima, for your helpful insurance insights. This brings us to the end of our presentation today. And just to summarize, in terms of the closing takeaways, I would suggest three things. Estate planning is fundamentally about control, tax efficiency, liquidity, and family protection. And the most important, most effective tax plans or estate plans are integrated across legal, tax, insurance, and business considerations. And lastly, you heard from all of us that early planning journey creates more flexibility and better outcomes. With that, I will now hand it back to Monica to see if we have time to take some questions.
Thank you, Ahmed. We absolutely do. I am cognizant of time. That does conclude our 30-minute session. But since this episode is being recorded, then I say for those of you who would like to listen in on the Q&A, I don't think we'll go past 5 or 6 minutes. But you can always go back and watch it in the recording. So first of all, I'd like to thank Ahmed, Brett, and Nima for their time and sharing their expertise and insights with us today. If you do have questions for any of our speakers, their information is on the screen. Please feel free to reach out to them at any time. We hope that you enjoyed the webinar and you found it helpful. You found some useful considerations for estate planning. So with that being said, I will just, I have some questions that we received when we did the registration, and I would like to just kind of throw them out to each speaker. So first we will start with Ahmed. In terms of planning for taxes, what are some of the planning strategies that can help reduce taxes payable upon death?
Thank you, Monica. It's a really good question. We touched on a few strategies during my presentation, but for business owners, for example, implementing an estate freeze at the right time is one of the most important tools to minimize taxes. So, as I mentioned, all assets, including business shares, are deemed to be disposed of on death. An estate freeze combined with lifetime capital gain exemption planning can result in significant tax savings or deferral of tax, and if implemented appropriately at the right time. So I would name that as one of the more widely used tool, which is very helpful for business owners.
Mm-hmm. Brett, I love that you said, it's good to have a plan before you need the plan. So speaking of plans and agreements, how often should a shareholder agreement be reviewed or updated?
Yeah, thanks, Monica. Great question, one that we get all the time. I mean, I'd say that there's no hard and fast rule for how often a shareholder agreement needs to be reviewed, but generally you want to revisit it whenever there's a meaningful change in the business or in the lives of the shareholders. So that could be bringing in a new shareholder, significant growth in the business, changes in management or ownership, or even a major health or family change affecting one or more of the shareholders. It's also particularly important when someone starts thinking about retirement, succession, or a potential sale of the business. But I'd say that even if nothing significant has changed, it's still always a good idea to pull it out every few years just to make sure that it still reflects how the business actually operates and what the shareholders want.
Yeah, good. And then Nima, we received this question. I need to take care of many things for my estate planning. Throughout this process, when is the best time to get my life insurance?
As we kind of touched on it, we are buying the life insurance and getting our life insurances with age and health, and then we pay it with money. The younger we are, the cheaper it is. Healthier we are, the more cost effective it is. But keep in mind, it's not only about the opportunity cost. Health changes can render us ineligible for getting a life insurance. So the best time is literally today. I would borrow something from what Brett mentioned. In this particular case, fast and quick is the kind of food. And one of the challenges that people are facing is that while the other part of their estate plan is being figured out, they don't know exactly about the ownership of the policy or the amount or the type that they need. Normally, we would suggest to secure your insurability by applying amount of insurance through a term insurance as a placeholder, secure and lock in your insurability, and down the road you can convert that or shift the policy to the right place. So today is the right answer.
Thank you. Brett, I have another question for you. What is the biggest mistake you see business owners make when it comes to corporate succession planning?
Yeah, I mean, lots of them. Probably don't have time to get into them today, but I'd say the biggest mistake is probably just waiting too long to start the process. A lot of the legal and corporate issues that come up in succession planning aren't actually that difficult to deal with when you have time and everyone is still aligned. The problems arise when you're trying to address them under pressure. So, in the middle of a sale, after a shareholder dispute has started, or following an unexpected illness or death. At that point, you have fewer options, the process tends to be more expensive, and you're often making very important decisions at the worst possible time. So I'd say, generally speaking, the earlier you start thinking about succession planning, the easier and cheaper it is to put the right pieces in place.
Mm-hmm. Yeah, great. Ahmed, how long is the estate planning process? When should this process be started, and what are the typical costs involved?
Thank you for this question. I get that quite often. I say that each situation is unique. If your records are up to date and organized, and the asset mix is not that complex, then I would say the process would typically take within 1 to 2 months. You can go from start to finish. In terms of when to start, generally speaking, we heard today, sooner the better. Some strategies do take certain or require certain amount of time to lapse before we can benefit from it, such as benefiting from lifetime capital gain exemption requires you to have at least 2 years before there's an actual liquidity event. So there are some hard deadlines or timelines which we have to manage. That's why we want to start earlier than or sooner than later. In terms of the cost, it depends on the time required, the complexity of the corporate structure, asset mix, whether a professional evaluator is required. It's difficult to provide a precise estimate but for tax planning fee, I say a basic plan generally start at about 10,000. I can, however, say that in every case, the cost will be much less than the cost of doing nothing when you factor in all of the various benefits we just heard today, including potentially very significant tax savings. So, I would say, I can't pinpoint the cost or provide you a hard and fast kind of yardstick, but generally speaking, these are the basic parameters.
That's true. I mean, if it's even better if you have the information and you can prepare rather than not knowing and finding out the hard way. So thank you for that, Ahmed. Nima, I have one more question for you before we wrap up. Various insurance options are available. How should I choose the best product and solution tailored to my own situation?
Yes, there are many options out there in the market. But before we focus on the product, the exact product that you would pick, you would need to find the right insurance advisor, someone that has the experience, expertise, and also a professional network around them to support you. This is not something that can be done in silos. What it matters is that you would definitely need right legal counsel next to you. You would need tax strategists and CPAs next to you, and also an insurance advisor. So first of all, choose someone that has that professional network, or at least can offer you referrals through that. And when it comes to picking the right product and the solution, there are many top insurance companies in the market. This is about, it's not about picking the right product, it's finding whatever the requirements are. And then based on the requirement, design the right product and the solutions based on your needs. And that basically draws down on the experience and expertise of the office and the advisor that you pick and select.
Perfect. Thank you so much. So I just want to thank all of our attendees for joining today. We will share the recording of the webinar, and if you have any questions, you can either respond to the thank you for attending email or feel free to reach out to any of our speakers here. Thank you so much, everyone. Have a great day.
Thank you.
Thank you.